common question that is asked by employees and indeed employers is about the whole area of cutting the employees' pay. Clearly, a lot of businesses are under pressure at the moment, and one of the ways they're looking to cut costs and make themselves more efficient is to cut the employees' pay. So, I mean, the question is, can the employer cut the employees' pay? Well, reducing employees' pay is problematic. As I say, employers seeking to cut costs of doing business is natural and common. However, to do so unilaterally without the consent of the employee may well be a fundamental change in the contract of employment, and the contract of employment, any change to it, must be agreed to by both parties. Now, essentially, there are two schools of thought in relation to cutting wages or pay of staff. One school of thought will claim that there is a common clause in most contracts allowing for the contract to be varied. Therefore, you can cut once you have this clause in your contract. However, there's an implied term of any contract that any change to it must be reasonable. So, it could be argued, or can it be argued, that cutting pay is not reasonable. Certainly the employee may well argue that if they sue for a breach of contract or claim for perhaps a constructive dismissal. So to have any chance as an employer of changing the contract, the variation of a contract clause really should be present. There's a second school of thought then among legal professionals, and they're of the opinion that you cannot cut wages safely without leaving yourself open to a claim from an employee without the consent or agreement of the employee. They would argue that consultation, explanation and agreement are certainly strongly recommended. Another way perhaps of cutting the total wages cost may well not be to cut core pay as such, but to cut benefits. For example, perhaps a company pension scheme or shares or a company car or something. They may be more fruitful areas for the employer to reduce his overall or her overall wages bill. In any event, if a cut is agreed and carried out, then clearly there's a change in the employment contract. So notice to the employee is essential under the Terms of Employment Information Act of 1994. It's a statutory obligation on the employer, and rather than giving this afterwards as statute will dictate, it may well be advisable to give that notice in advance. The employee then has redundancy considerations to think about, because the employee, if she agrees to the cut, will have to consider that the rate of pay for the purpose of calculating redundancy will be the rate of pay in being at the date of termination of employment. That's the reduced rate then, if she's agreed, not the old higher salary that she may have enjoyed. For more information about employment law in Ireland and employment rights and so on and so forth, you can visit our website businessandlegal.ie. Just check out the employment law page, and please accept our free employment booklet. We have an employment booklet. It's a short booklet which you can download for free. It's called 16 Common and Costly Employment Mistakes Made by Many Irish Employers. Thank you.